Now, the Supreme Court has, in a unanimous decision, ruled that the whole High Court erred when it granted an injunction against the gazetting of John Peter Amewu as Hohoe MP-elect. The court said the case filed by the Sal residents requested some reliefs that can only be granted through an election petition and not a human rights issue as has been filed. It therefore set aside the portions of the case at the High Court that is requesting reliefs relating to election of Amewu as MP for Hohoe. Court correspondent Joseph Akable is joining me with more. Hello, Joseph.
3.
So, Joseph, let's begin with what the court, the reasons given by the court for the decision taken, apart from the ones we've already stated.
And so the court made a point that the issues about whether or not the people's rights were breached when the Electoral Commission organized the elections at the Hohoe constituency without their inclusion are not matters that affect the validity of John Peter Amewu as a Hohoe MP. It says that he in no way did not prevent anyone from voting that particular election. He simply put himself up and was duly elected. And so if there are any concerns relating to his election, the appropriate forum is certainly the High Court, but it should be going by way of a petition instead of filing an action in the form of a human rights action seeking to seek reliefs that are of the nature of an election petition. And so the court said that the High Court judge erred when he granted that particular injunction, but it will not set the injunction aside because the injunction as it stands has elapsed. It was to last for 10 days and it elapsed about 3 days ago. And so there's no injunction to set aside, even though it establishes that indeed the judge was wrong in granting that injunction. The court now picked the case that has been filed at the whole court and set aside all aspects of the case that are asking for reliefs relating to the validity of the election of John Peter Amewu as the Hohoe MP. And so all those aspects of the case were set aside.
Well, Joseph, you've also been getting some reactions on the back of this court case. Tell us.
So I spoke to the Deputy Attorney General Godfrey Deboadami. He says the decision is in the right direction, but I also put the question to him about, justice has been served, but what happens to the residents of Sal, because they also deserve representation. We can take a listen to him speak to us about the decision and address the concerns relating to what should happen to the residents of Sal.
Indeed, we are very grateful to the court. We're happy that justice has been served. Right from the outset, our contention was that the action filed at the High Court, who was incompetent, was totally out of order because you cannot seek election petition reliefs in a human rights action. And today, the court has held to the same effect, that was unjustified for them to have commenced an election petition and characterize him as a human rights action. So we're very grateful. And I think that it's also important for me to place on record certain misconceptions and misperceptions that have been made about the intervention of the Attorney General in this matter. And that is clearly because the Attorney General was sued. The Attorney General was a party to the High Court proceedings at Hohoe. And if you are party to proceedings, you reserve the right to take any action at all that you think is available to you at law. And that is what the Attorney General did. We commenced an action here at the Supreme Court seeking to quash what went on at the High Court because it was not according to law, and it was granted by the court. Well, so our contention was that the matter was in the nature of a parliamentary election petition, and to that extent, the orders of the court dated 23rd December ought to be struck out. The court granted an order of certiorari quashing the entire proceedings of the court on 23rd December 2020. So we satisfied wholly with that one. Then the second relief for prohibition. The court granted same to the extent that it struck out the reliefs that were in the nature of an election petition sought against John Peter Amewu to restrain him from being gazetted, to restrain him from being put before Parliament for swearing in and all. That have been totally struck out by the court. And that's essentially what we thought would be justice in the circumstances. We are happy and very much satisfied with the orders made by the court today.
What happens to the people of Buem? What happens to the people of Buem who equally deserve justice?
Indicated. I think that the Buem issue, for me, is a simple and straightforward one. The court today has upheld the validity of CI 128. The court had indicated that clearly CI 128 was constitutional, and the interested parties led by Chikata had failed to produce any evidence whatsoever impeaching the validity of CI 128. So, as far as I'm concerned, to the extent that CI 128 had placed the people of Central Kofi, Akpafu, Likpe, and Lolobi under BUEM, it resolved the issue. I think the consequence to all of this is that the BUEM election, if you ask me, yes, for me, was improperly conducted to the extent that it excluded the people of Central Kofi, Akpafu, Lolobi, and Likpe. So I think that the proper thing to do is for the Electoral Commission to perhaps look at that issue and take due steps that will warrant a conduct of the BUEM election again. That's the most important thing. Of course, I'm also aware of the pendency of a suit filed by certain people seeking to have the BUEM election annulled and for a fresh election to be conducted. I think that issue will be dealt with by the High Court. And indeed, the court today, when it was preserving the part relating to human rights to be continued at the High Court too, clearly also is thinking on the same line. So that issue can be resolved by the High Court, and the conclusion can be that the BUEM election should be conducted again. Because the court has indicated today clearly that the people of the 4 areas in question cannot be part of Hohoe. They are not part of Hohoe as per law, because to do so will be an infringement on Article 47, Clause 2 of the Constitution.
Well, that's Godfred Yeboah-Dame, the Deputy Attorney General, speaking to other journalists and my colleague who is also on Zoom with me. Joseph, so the point he makes is that, well, the High Court can deal with the issue of human rights, but they certainly are excited. What does the future hold for this group of people? I mean, the Sao enclave.
So as it stands, I mean, they do not have an MP in terms of how Parliament is composed and how it will look on January 7th. But what remains is they have a human rights action that is pending at the whole High Court, and so they can pursue that action and ask for the necessary relief to be granted them, including possibly asking that they be allowed to vote in the constituency where they are eligible to vote in. And that is what the AG says. He doesn't think it's the Hohoe constituency, but rather in the BUEM constituency. And so they can still go through the direction of the human rights issue at the whole High Court. And in terms of Mr. Amewu's own election, it means that nothing stops him from taking a seat in Parliament on January 7th, giving the MPP the 137 seats that they've always said they actually have.
They saw enclave, people who, in this particular case, were they represented by legal counsel in court, and what did they say? What was their reaction?
Mr. Chikata represented them. He declined to grant us an interview. The only response he gave to the panel, in fact, after the decision had been rendered, ordinarily they are expected to stand up and acknowledge the decision. He didn't stand up until he was prompted by Justice Yapo, who was the presiding judge, who said to him that, Mr. Chikata, you are our lecturer, but the court has ruled. Then he just said that as the court pleases, then he resumed his seat again. When he came out, we tried to speak to him. He declined to grant us an interview.
And give us a mental picture of what the court looked like today. Were they people from this area who, came to check out what was happening with their case, or was it just about the representatives, the legal counsels that they had?